Residuary power, Malad.
Residuary power came in and when? Under what?
Other way around, Malad.
No,
Kashmir, it was there from the beginning.
Where does the residuary power find?
Yes, I'll show that to you, Lord. This is part of the instrument itself. The constitution of that's the purpose.
Mr. Sibal, you have contradicted yourself. When you refer to clause C,
and saying this is a blanket power, then it's the president can do it anytime without any consultation.
One
just passes an order. It had to be, Malad. There was nothing there at that point in time. It had to be, Malad. It could never be a permanent thing.
So why did the Constitution then put it in part 21?
Because
just one question on this. B1 refers to those matters in the instrument of accession which have been ceded by the Maharaja to the Dominion's power. B2 refers to all other matters in the union and concurrent list other than what is covered by 1.
Fair enough.
Now suppose in the area of the union and the concurrent list, something is not covered by B1 or by B2. In other words, it's not referable to those subjects mentioned in the instrument of accession, and it's not covered by B2 at all. That power is not entrusted to the state.
B2 is all other lists, Malad.
No. B2 says such other matters in the said list as with the concurrence of the government, the president may order specific.
So all matters in the list.
Right. Of course, it covers. It's a residuary.
Everything.
Yeah. So you have to take the concurrence of the state.
Yes.
Now, suppose it is not covered by B2 in the sense that there is no concurrence of the state, right? It's not covered by B1,
yes,
and you have not taken the concurrence of the state under B2.
Correct.
On such an aspect, the state legislature cannot exercise power because it's not in the state list. One second. One second.
Residuary power.
One second.
Yeah.
The state legislature, the state legislature is operating on the state list.
And residuary power, Malad.
Residuary power came in and when? Under what?
Other way around, Malad.
No.
Kashmir, it was there from the beginning.
Where does the residuary power find?
Yes, I'll show that to you, Lord. This is part of the instrument itself.
Instrument of accession.
Yes, it is part of Malad's all orders of the government.
No, but has specifically there's
it's also part of the constitution. Malad, I'll show
I
that.
just wanted to see whether it's part.
Yes. Your government should take it, Malad.
Because otherwise there'll be a peculiar situation.
Yes.
Where neither parliament can exercise power, nor can the state legislature exercise power.
I take your lordship's point. I will demonstrate to your lordships that the residuary power was with the state legislature throughout and with the state government throughout. That was the condition on which, Malad, the accession took place. And I will demonstrate that to your lordship. That's the least of my problems.
Which is very different from what is subject matter of 1 and 2.
Yes, right.
Because they do not deal with abrogation of the article.
Absolutely. Right. Yes, absolutely. Your lordship is right.
And therefore, when we read at that power, which is specifically conferred on the president, then proviso, leave aside for the time being the proviso. Do you agree with that interpretation?
No,
for the time being, just leave the proviso.
Well, I can't read the constitution in this fashion. I can't even read an act in that fashion. Let's forget the constitution. How do I leave the proviso when the constitution is staring us in the face?
No. The question was, therefore, clause 3 deals with abrogation of the article itself, which is not the subject matter of 1 and 2.
No, it's subject matter of C. Article 1 shall apply to the state.
No, correct. But it deals with complete abrogation of the article itself.
I agree.
And in that context, you may argue that your argument at the first fold was, it will be only if the conditions of the proviso are satisfied, that clause 3 will apply. Otherwise, if the conditions of the proviso are not satisfied, clause 3 will not apply.
That's how your lordships have interpreted proviso since 1950, Malas. That's all that I can say. I can't say more than that.
A proviso may in some cases be an exception. A proviso may in some cases be an elaboration.
There's a difference, Malas. Yes.
It depends upon the nature of the
provisos are sometimes change colors.
Proviso, Malas. Proviso that the recommendation.
Rule for a proviso in that sense.
Provided that the recommendation of the legislative of the Constituent Assembly shall be necessary. It's a restriction on the exercise of power. That's right. Referred to in clause 2, Malas.
To interpret clause 3 to say that the power existed and then will vanish once the Constitutional Assembly of the state no longer exists.
But you kindly read two, Malaz. If the concurrence of the government of the state referred to in para 2, subclause B or 1 or the second proviso to D of that clause be given before the Constituent Assembly for the purpose of framing of the Constitution, that's the purpose.
Mr. Sibal, you have contradicted yourself. When you refer to clause C, subclause C is an independent clause, and clause D not applicable to clause C.
No,
then
what
the
I'm
second
saying
proviso will not apply.
Both cases.
And therefore only subclause 3 will apply.
Malaz, point is clause 2 says that
clause 3 will apply.
even for the purposes of those notifications.
Anyway, we'll examine that.
Yes.
We have understood your line of argument.
No, there is something that's missing, Malaz. The proviso says, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2. Why are they saying that, Malaz? The purpose is given in clause 2. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary for the president before the president issues such a notification. It is necessary and before he issues it. How can you say it's explanatory or that it's an independent clause? It specifies how it is to happen. It has to happen before. That is, the permission has to have before.
You know, the reason why clause 3 refers to the Constituent Assembly of the state referred to in clause 2 is because clause 2 refers to the Constituent Assembly for the purpose of framing the Constitution.
That's correct. That's exactly right.
That's your point. You get that point.
Yeah.
Now, therefore, the recommendation of which Constituent Assembly, this makes it very clear that one and only Constituent Assembly which was formed for the purpose of framing of the state constitution.
Right.
Once the frame of the constitution was done, then that purpose of the Constituent Assembly is not like a permanent body. Like Parliament is a permanent body. The Supreme Court is a permanent body.
No doubt about it.
It's a body which has a specific purpose and then after it becomes functus officio, so to speak. Therefore, once the Constituent Assembly had fulfilled its purpose, then the proviso itself has no application.
No, this is the problem, Malaz, with the problem there is when you are applying 3 without the proviso and saying this is a blanket power, then Malaz, the president can do it anytime without any consultation.
One thing which we must
passes an order. I integrate.
One thing which we have to also bear in mind is all these provisions are in Part 21. Part 21 has used 3 expressions: temporary, transitional, and special.
Correct.
Temporary provisions are those which are intended to be in existence for a limited period of time,
That's right.
but without a point of terminus, right? A temporary government servant. That person is temporary for a limited period of time, but whose services are to be terminated. Until you are terminating the services of that person still continues.
Right.
That's that broad concept, of temporary.
Absolutely right.
Transitional means something which necessarily has a terminus.
That's right.
Laws made earlier. I'll show you some of the transitional provisions in this part.
Right.
And third is special.
Right.
Now we'll see, for instance, after 370, we'll get some idea from the provisions after 370. Say 371, special provision with respect to Maharashtra and Gujarat. 371A, special provision for Nagaland.
Yes.
Then we get 371B, special provision for Assam.
Correct.
371C, special provision for Manipur.
That's correct.
D, for the state of Andhra Pradesh and Telangana.
Right.
E, establishment of Central University in AP. F is special provision for Sikkim, which came in 75.
Right.
G, Mizoram. H, special provision for Arunachal.
Yes.
Then I for state of Goa. J for the state of Karnataka.
Right.
Now, after these special provisions end, we come to 372.
Right.
Which continuance in force of existing laws.
Yes.
Which then says, shall continue in force until altered or repealed or amended by competent legislature or by any other, like the penal code.
Right.
It just continued in force until it is altered. Then similarly, now we have 372A, power of the president to adapt laws.
Right.
And it says the president may by order made before the 1st of November 1957 make such adaptations and modifications.
Right.
So this was a transitional provision. That the president had to make those adaptations by the 1st of November 1957. So it was a transitional provision. After that, the power lapses. So similarly, 373, then came the provisions relating to the judges whose services had to be taken over by the Union of India. public service commissions, so on and so forth. And then 392, the power of the president to remove difficulties.
Right.
So therefore, Part 21 basically covers special provisions, temporary provisions, and transitional provisions.
Right.
Now, it doesn't use the expression transitional in any head note or marginal note to the articles, but temporary and special are used in the marginal notes to specific articles of Part 21. And 370 specifically uses the expression temporary.
It had to, Malad. It had
So,
to.
can we then, by saying that the power under clause 3 goes once the Constituent Assembly comes to an end, really convert this into a permanent provision, which it was never intended to be by the Constitution?
But that's, Malad, your lordships are now putting to me, it was never intended to be. In 370, when it was put in, it had to be a temporary provision. It had to be, Malad. There was nothing there at that point in time. It had to be, Malad. It could never be a permanent thing.
So why did the Constitution then put it in Part 21?
Because, Malaj, it is a separate, it relates to a particular state where the two sovereigns have come together and made a compact which is incorporated and integrated.
No, Part 21 does not deal only with Jammu and Kashmir. It deals with other states.
I'm sorry, I didn't get.
Part 21
Yes.
does not deal only with Jammu and Kashmir.
No, of course not. That's why I think it is a separate, independent provision and has to be interpreted on its own terms. You can't incorporate Malaj's concepts outside of 370 and integrate them into 370 and say this is how we'll read 370. 370 is not temporary.
The note expressly says it's temporary.
No, it says temporary provisions with respect to temporary provisions. In other words, this is a provision which is temporary till such time as the Constituent Assembly decides this way or that way. That's the whole